That is the defense opening statement. Yeah, I had a 50-50 shot. I thought we had the prosecution for you there. But you would not believe how many people are yelling in my ear when I get that wrong. My mistake. Sorry. So we hear from the defense that they're, Jonna, among other things, poking holes in this money motive.
Right.
Let's face it. Even if you believe that $40,000 was owed.
Okay.
I mean, are you going to kill your business partner, his wife, 2 kids? I mean, what has to go horribly wrong for you to do that?
Well, you'd like to think that no amount of money is enough to kill somebody else. But when you put this in context, in the grand scheme, a lousy $40,000 debt, and as the defense pointed out, he was worth so much more alive than dead because they had money coming in, or they were going to have money coming in. So the money motive is not the only thing that falls flat in this case, though. I think that there's just a sheer lack of evidence to connect all the dots here.
Yeah, I mean, the only connection, Terry Austin is also here with me, trial attorney. Yeah, they work together. That's, you know, I have no doubt about that. But what about connecting this defendant to the actual murders, maybe a little better to the burial site where they do have a cell ping here or there, which as everybody knows, I don't like that science. I think it's a little shaky, especially when you're in the middle of nowhere. But Terry, what do you think? What other problems does the process have here?
I think the prosecution has a lot of problems. One of the issues in this case is Mcstay is the biggest person here who could have been the perpetrator. They don't have anyone else to blame for this, and so...
And if the prosecution could count on a could-have-been burden of proof, I think they'd have a much better case. Okay, let's take a look now at somebody who's crunching the numbers here. This was testimony from a forensic accountant in the Mcstay case. Very interesting here. This is the defense expert, forensic expert, and the name that keeps coming up is Dan Kavanaugh. As we all know, he was another business partner with one of the loosest business arrangements I've ever heard of. You know, nothing really kept very clean on the books, but this guy, as you can tell from how he looks there, is very creative. And so he was one of the software guys who was working with the defendant and with the deceased, and quite often the defense has thrown a little shade on him to suggest that, you know, he had the greater motive to kill Joseph Mcstay. So let me ask Terry first, what do you think? Is this believable? Is it as weak as the prosecution case?
I think that the best thing a defense attorney can do is use another name and say it could have been someone else, especially if there is no real hard evidence against either one, because as you know, it has to be beyond a reasonable doubt. Put a little doubt in the mind of the jury, and you might win. So
here's an interesting little wrinkle, a new development from Kathy Russin out in California. Dan Kavanaugh has been missing in action in terms of this trial. Everybody's been waiting to see this guy for many, many reasons. It's, you know, anytime you put on a trial and a name keeps coming up over and over and over, the jury's like, when's this guy or woman walking through the door? Well, Dan Kavanaugh was subpoenaed and seems to be missing in action. Nobody can find the guy. Now, Jonna, I've had this weird theory, and I was told it was a weird theory.
I love weird theories.
You like the weird theory? The weird theory I have is that the defendant, Charles Merritt, worked with Dan Kavanaugh to bump off their business partner so they could take over the company themselves and do all those things they needed to do. They created the alibi that Dan Kavanaugh was in Hawaii, so he would be no longer a suspect, and the cops moved away from him pretty quickly. Then the evidence against Charles Merritt is as flimsy as we've suggested. So he gets off. The prosecution can't then go after Kavanaugh because they would look like idiots. Oh, you mean this is the real guy, not the last guy that was the real guy.
Right.
What do you think now that Dan Kavanaugh seems to be missing in action?
So that is an interesting theory. The wrench in those works, though, is, do you think, according to that theory, did they plan on Charles Merritt having to stand trial, or did they plan on the police just simply saying, we don't have enough, nobody's going to get charged with this?
Okay, that's, Terry, you tell me. I would have a plan A and a plan B. Plan A would be he's not charged and we all walk away. Plan B is he is charged, but we've covered the trail so well he can't be convicted. So it's a bit more of a gamble. What do you think?
Right. I think Plan A would be...
Plan A would be best.
Yes,
yes,
Plan A would be best.
Yes.
I think in this case, you know, whatever the evidence is going to show, the prosecution is going to lean in that direction. If it shows that Merritt had more factual evidence against him, they're going to lean more towards that. If it shows that this absent Kavanaugh might really be the one, I think they're going to bring evidence in whether he's there physically or not.
Okay, we're going to see if Kavanaugh surfaces, and certainly if he walks through those courtroom doors, it will be amazing, and we'll be there for that if it happens. We're going to take a quick break. We're going to stay in California, and when we come back, because another case is launching there, just began yesterday. It's called the Hollywood Ripper case. We're going to get into that when we come back to Law&Crime.